Welcome to Cutler Legal, Basic Law. Today we're going to talk about bylaws. First question, what are bylaws? Bylaws are a document that control the decision making for a corporation. They are the distribution of power between the shareholders and the directors, and can set forth the directors' duties and obligations and powers, as well as the shareholders' duties, obligations, and powers. Next question is, what are generally in bylaws? First thing is, how many directors? What are the directors' responsibilities? How much power do they have, i.e. what decisions they can make? The appointment of a director, the removal of a director, transfer of shares. Under what circumstances can a shareholder sell his or her shares or transfer his or her shares? To whom a shareholder can transfer his or her shares? And this is particularly important in what we call a closely held corporation. That is a corporation that only has a few members. It's not like a publicly traded corporation, but it's more like a partnership than a corporation. And often you want to control who gets the shares. You may not want the shares to be transferable during a divorce. You may require them to revert back to the corporation if someone gets divorced, because you don't want that shareholder's spouse, whether male or female, to become a member of the corporation. Or you might be very particular who can be a member of the corporation, so you restrict who the transfer can be to, if there has to be approvals, or the corporation has an automatic right to buy the shares itself. The type of stock that will be issued. There may be preferential stock that has special voting rights, general shares that have the same voting rights or less voting rights, and so forth. That could be put forth in your bylaws. Meetings, when meetings are held. You have two sets of meetings. You have the board meetings, and the board makes the general decisions for the corporation. They often elect the CEO and make the big decisions. Then you have the shareholders, who also make decisions, but primarily the big decision the shareholders make is to elect the board members, and then the board members run the company. It doesn't have to be exactly that way, but that's the normal way. So you have to set forth in the bylaws when these meetings are to take place, how they're to be conducted, do you need a quorum, etc. Next thing is distributions. When distributions are to be made, how they're calculated, etc. Another big issue is, are there times, particularly in a small corporation, where the shareholders have to put money into the corporation to finance the corporation? Do you want to require that, or do you not want to require that? With regards to distributions, should the corporation pay the taxes on those distributions or not? Those go into the bylaws. Dissolution, that's really important. Let's say we want to dissolve the corporation. What is the process? How do you do that? And it's a good idea to put that into the bylaws. So if there's a time when no one's getting along, or it makes sense to dissolve the corporation, there's a process and set of procedures to follow. And then, of course, if the corporation is dissolved, how to split up the assets. All right. What should you watch out in the bylaws? Say you're investing in a corporation, someone hands you the bylaws. First, always remember that if you're investing, you can always request those bylaws be amended if you have concerns. So the big thing is, how are decisions made? What input do shareholders have? What control will you have as a shareholder? Will you be a board member? How easy is it to remove you as a board member? How easy is it to be put on as a board member? Monies. Often in closely held corporations, those are small corporations, a lot of the money goes out in salaries. So if the people controlling the corporation take out all the profits in the form of salary, which would be characterized as costs, that leaves nothing for distributions. So you could put $100,000 into a corporation expecting a 10% return, but the corporation never makes any money, but the revenues keep going up and its costs are stable. And the reason there are no distributions or no profits is because the people in control are increasing their salaries or taking big bonuses and taking the money out before it's available to be distributed as net profit. As I mentioned, watch out how voting is done, how board members are appointed and removed, how a deadlock is resolved. Let's say you only have 4 board members. Well, if 2 vote one way and 2 vote the other way, you have a deadlock. How is that dealt with? And then finally, can a shareholder compete with the company? You want to be very careful. You don't want shareholders, or certainly board members, who have inside information also working for another company that has competing products or services. Finally, what happens if there are no bylaws? Then you have to revert to whatever the statute is for the state in which the corporation is created. Remember, corporations are state law creatures. They're created by state law, not federal law, but state law. So look at the state that the corporation is created. Let's say it's created in Kansas. Then you look at the law of Kansas, or Texas, the law of Texas, or Florida, the law of Florida, and certainly the law of Delaware. And what does the statute say there? So if there are no bylaws, you look to that statute. But you never want to be in that position, because people need predictability. You need to know how to resolve problems, how the company's going to be run, and the bylaws set that out. So always make sure you have bylaws. You can amend those bylaws if things change, but it's better to have a set of bylaws than none. All right, I hope that was helpful. Thank you.